Is the allegation alone of domestic violence probable cause to arrest, right? Hey guys, it's Anthony here, bringing another Roadside Chat. So the question is the allegation alone of domestic violence probable cause to arrest, right? So this comes from an officer in California, and the officer is giving he's inserting the Penal Code, which is Penal Code 836, arrest without a warrant. This is applicable to, I think, all officers. I know that we're going to be talking about Penal Code. And it basically says, anytime a peace officer is called out on a domestic violence call, it shall be mandatory that the officer make a good faith effort to inform the victim of his or her right to make a citizen's arrest, unless the peace officer makes an arrest for the violation under a different section. This information shall include advising the victim how to safely execute the arrest. So I'm not familiar, quite frankly, how California allows these arrests to actually occur. I don't know when it says safely execute the arrest. I think it's just language like how to safely put them in custody, I guess, but it looks like the officer in reality in modern times is going to be actually making the physical custodial arrest. So the officer says, hey, look, after reading this, if you have no evidence of a domestic violence incident even occurring, right, only an allegation, like no physical marks or bruises, no witnesses, and this he said, she said, the supposed victim or suspect is saying, no, that's not what happened. I didn't touch her. You are informed, you are to inform the right of a citizen's arrest and then accept that arrest. So again, the scenario is that you get dispatched with domestic violence, you arrive and talk to both parties. One of them says he pushed me, the other denies it, no physical marks can be proved or seen, no witnesses, no video, nothing, just this allegation. Is this allegation alone enough to for probable cause to arrest? Well, all right. So first of all, I got to make it clear. I'm trying to help cops here. I'm not your legal advisor. I'm not your prosecutor. I cannot give you legal advice. I'm not your attorney. I am an attorney. I'm barred in all in 2 states and teach all over the country. But just remember, I'm not looking to supersede what your prosecutor will tell you, but I'm going to tell you what my advice here. Number one, this is a little uncharted territories. I looked in Westlaw under the section to try to find a case on point about an officer making an arrest that was later found to not have probable cause and what will be the consequences. Now, let me just give you some guidelines. Number one, I did read a case a long time ago, and I did not save it, and I apologize, but I did not save it. But I usually save all the cases I read, but it did talk about an officer conducting a citizen's arrest, and knew that there was no probable cause, but basically just took the arrest anyway. And the court, obviously, for good reason, found that was a bad arrest, right? That the officers can't be, like a person's personal, henchmen, right, for other people to make arrests for bad faith arrests. So I guess the point is this: if the cop really, in good faith, objectively sees that this is not a crime, and I guess a good example of that would be that the citizen, maybe domestic is not good, but the citizen believes that an offense occurred, and the cop is like, no, look, if I saw that exact same thing, I would not believe that a crime occurred. What I think the cop should do in that case is make a report, and you can submit it to your prosecutor for consideration of charges. So there's the first principle. The second principle is that you are allowed to presume that witnesses and victims of crimes are reliable, that they're not trying to lie to you and trick you. However, we always want to be cautious with domestic violence victims. They could have an axe to grind. They could be, in a dispute over property, and now, or maybe the person has firearms, and the victim knows that they may get their firearms removed, and this could really upset the alleged suspect. So here's what I'm going to tell you: use good judgment, and if there's no reason to believe that the victim is lying, you don't see that other conflict, they look like they're telling the truth, they have the appearance of being truthful, there's no other things about their veracity, like being highly under the influence, not necessarily knowing what's going on, you're not catching the lies in anything else, but basically overall you're like, yeah, look, I do there's reasons to believe you, I don't think that you're trying to lie to me. Then I think the law is clear. I think that California law is clear. I think that in California, if the offense occurred in their presence and it's a misdemeanor, that they are allowed to make a citizen's arrest. And the law is telling you to make a good faith effort to advise them of that. So what I would do in California is, if I would take them at face value unless something else was coming in, and then I would get other people involved, sergeant, DA, and so forth. And if they want to make that citizen's arrest, then I would make it, and I would do my report. And if the suspect later proves that the alleged victim was lying, then they can sue that person for malicious prosecution, right? But you're the middleman here, and you've got a job to do, and it's very tough to be in the middle. But if they're alleging that they were pushed unlawfully, right? They were unlawfully battered, and there's no other reason to not believe them, I think the arrest has to be made if they want to do a citizen's arrest. That's how I feel about it. All right. Now, of course, you got to look at your state law, and if you're still uncertain here, you've got to ask a prosecutor. All right. That's my 2 cents on it. Hopefully it helps to some degree. All right. Keep the questions coming. You know the drill. If you like what I'm doing, like, subscribe, comment below, let other people know that you like this stuff, and I'll see you next time.